We have 3 cases scheduled for oral argument this afternoon on the docket. Our first case is Eddie Dorsey and Audrey Dorsey et al. Versus Franklin Robinson, Josephine Robinson, and Mary Thompson. Counsel ready to proceed? You may approach counsel. Counsel will allocate 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, sir. 5 minutes.
So noted, Madam Clerk. You may proceed, counsel.
Good afternoon. May it please the court. I'm Wendy LaQuasto of Fox and LaQuasto. I'm here today representing appellants, the Dorsey family. This case presents 4 issues, and with the court's permission, I am going to rest on the arguments and remedies requested in the brief on the second, third, and fourth issue because I think they rise and fall to a certain extent on the first issue. The second issue and the fourth issue, as you will recall, involve the partition claim, which was denied, and the fourth issue is on the tax apportionment, and I think that those are really related to the first issue and the title issue. And the third issue, I think that that's a straightforward lack of CSE. That deals with the partition orders that were purportedly entered in the 70s. So I'm happy to answer any questions about those, but my time's limited, so I'd like to focus on the first issue with your permission. On the first issue, which has to do with the interpretation of the possession exception to the Marketable Record Title Act, I'm going to call that MARTA. I think everybody's on the same page about MARTA, what its purpose is, and that the 1985 deed is the root of title. The dispute in this case goes to the interpretation of the possession exception, which is MARTA shall not affect or extinguish the following rights of any person in possession of the land so long as such person is in possession. The Dorseys maintain that the statute means that MARTA cannot affect whatever rights they have since they've been in possession of the land both before and continuously during the entire 30-year period that MARTA applies. So once the Robinson-Thompsons filed the quiet title action in April of 16, then that was for the purposes of determining everybody's interest and title to the property. Once that was resolved, then the exceptions under MARTA no longer need to apply because—
But counsel, can please point to the specific provision in the trial court's order where the court ruled that MARTA extinguished any ownership interest appellants had?
Point to the
provision in the trial court's order where the trial court ruled that MARTA extinguished any ownership interest appellants had in the property.
That's the judge's finding that they had a possessory interest. I don't know quite frankly, I'm not sure what a possessory interest is, but that's by saying that it's a possessory interest and not saying that it's fee simple, which the undisputed evidence shows here. They are heirs of the women who owned this property in fee simple. That's how they claim it. So I don't know, possessory interest, the Robinson-Thompsons argued throughout that they were some sort of lessee or that they, I don't know, at one point it was said that they were life tenants, but they seem to consistently argue that there's some sort of lessee, like a landlord-tenant situation, and their possession is akin to that. They have to sign leases, and that's what it is. So the provision in the order is that possessory interest. It may not be as clear as I'd like it to be, but that's what I'm maintaining it is.
Is that interest recordable in terms of, I mean, if you're looking in the property records, where would you see that interest? How would it appear?
Well, in some of the case law I read, I did see that there are, I did read in one case that somebody had recorded a lease, so I guess you could record a lease, but a lease isn't something that anybody can inherit. That's not, a tenancy. If you're a tenant, maybe your estate might be on the hook for the balance of your term, but it's not something you pass down from generation to generation. So, and I submit most leases are not recorded.
And so in the absence of that recorded interest, the people who do have a recorded interest would have a right to eject or remove those folks from their property. Would that follow?
Yeah, I mean, I think that that's what the problem with this whole interpretation by the trial court is that this is some sort of possessory interest, is that it actually frustrates MARTA. MARTA is intended, and I think, it's repeated in all the cases, extinguish stale claims and ancient defects in title, which is not what a lease is, and also to keep intact the exceptions that are in there, to not affect the rights that are in those exceptions. Here, by reducing their fee simple interest into some sort of possessory right, they've affected the rights that are in the exceptions, and they frustrated the purpose of MARTA, because by having a possessory interest for as long as they remain on possession, then the Robinson-Thompsons now own a piece of property that's subject to their possessory interest for as long as they stay there. I submit that if they ever wanted to sell the property, a bona fide purchaser for value who took this property subject to the possessory interests of the Dorseys would think that this is not clear title. And that's contrary to what MARTA is intended to do. So, and it's really, and I've repeated in my brief many times, this possessory interest, reducing a fee simple to this possessory interest, is exactly contrary to the opening paragraph of the exceptions, which is MARTA shall not extinguish or affect the rights.
And in terms of the statutory purpose of extinguishing stale claims, the possessory interest would have been open and notorious to anyone who saw the property, that it's being possessed and has been possessed for 30 to 50 years by most of the tenants. Is that correct?
Yeah, they've lived on, I mean, they have mobile homes or homes on this property. They live there, so yes, it is there. And certainly when the Robinson-Thompsons took the deed in 1985, they were there and they knew they were there. So yes, it is. I think this case kind of got off track and I think that this is another error that the trial court made, in addition to misinterpreting what that possessory exception is all about. It got off track because I don't think she just accepted, the trial judge accepted the Robinson-Thompsons theory that they have some sort of lease interest, that the Dorseys have some sort of lease interest, that it's something less than fee simple. And I pointed out in my brief that there's an analysis, that step by step where you would go through and you would determine what a person's interest is. For us, the undisputed evidence is they have fee simple. They inherited from their grandmother and their mother. And that's the evidence. There's no evidence of anything else in this record. And I submit that the trial court got out of line, or went off base here by not determining that and accepting this possessory interest. The other thing that I think the trial court did in this case that was wrong was I don't think she really applied the right, to the extent that this is some sort of factual matter, although I think it's also a matter of law, because I don't think she applied the proper definition of what possession is under MARTA. And, the case law, it's not defined in the statute, but the case law defines it as visible power or control over something as distinct from lawful ownership, holding or occupancy, control or occupancy. That's in the Dot versus Mid-Peninsular case that I cite repeatedly in my briefs. As to the 6 Dorseys that the Robinson-Thompsons stipulated had possession, they've got it. And even under the facts, they've got it, because they have lived there for before the 1985 deed and continuously after the 85 deed. So they have visible power and control. They live in their houses that are right there. As Judge Rose said, open and notorious, right there.
Does that analogy also apply to James Dorsey as well?
James Dorsey, and our argument is that, thank you, that was my next point. You must be following my outline here. But James, I made the argument in my briefs as, he also satisfies this definition, this visible power and control over something. It's undisputed. The evidence is he lived on the property until 1982, when he and his wife separated. And then he moved off the property, that's true. But as a landlord to that property, he allowed his wife, ex-wife, to continue to reside in his mobile home located on that property until she died in 2014. Since then, he's taken back possession of that mobile home. He takes care of that mobile home. He pays the tag on that. He does repairs to that, and he makes sure that the lawn around the mobile home is mowed. He has Eddie Jr. do that. So, you know, he has visible power and control over that place on the property, and so he satisfies that possession element too. And then we come to Lily Ruth. You know, I see I'm getting into my rebuttal time, but I just want to make a point about her before I sit down, and we submit that she also satisfies it. Yes, she was one of the first people she was one of the 3 that got the 85 deed. Yes, she signed deeds in 2005 that gave 18 to the Robinson Thompsons and 2 to her, but she has never lived on that 2 acres. She lives on the 18. She has continually lived on the 18 acres since 1978, and she's allowed her 2 daughters to live there too. So she satisfies possession. So based upon these mistakes, we would ask you to reverse, and I'm going to save the rest for my rebuttal, unless you have questions. Thank you.
Thank you, counsel. You may proceed with counsel.
Thank you, Your Honor, and may it please the court. I'm J.D. Durant with Boyd & Durant on behalf of the appellees. I agree with my good friend that the threshold issue in this case really is whether the trial court properly interpreted Section 712.033's possession exception. If it did, some of the other issues, whether a partition was properly denied, I think the answers to the one will give you the answer to the other. And Judge Rowe, I think a question that you asked really does touch on how the operation of MARTA was intended to work, how it typically works in the real estate market, and why the possession exception that survives under the court's final judgment is not inconsistent with MARTA's goal to simplify title transactions. And that is principally because the rights of tenants under a written or unwritten lease are typically not of record. In fact, unless the lease term is longer than 2 years, it would be inappropriate under the recording statute to even record notice of a lease. Whether such notice would be recorded in a commercial transaction is something that the parties can negotiate, but as a buyer of property and a closing agent handling a sale relying on MARTA to extinguish old and ancient claims, there would be no expectation that the possessory rights that don't appear in the chain of title are something that MARTA would extinguish.
So in that case, you know, and reading the statutory language, the rights to that possession is as long as they are in possession. And so that possession would turn on, you know, whether the property owner wanted to continue to allow that. I mean, what is that right dependent on, the possessory right? Because the order doesn't make that clear.
Your Honor, I think that's a fact-specific case. So the rights of a party in possession might be defined by a written lease agreement under the Residential Landlord-Tenant Act, where the term might be month-to-month or annual. It could be longer. Could be an unwritten lease, so you'd have to look to see how periodically rent is being paid. And here, where we had at least the allegation, the court never got to the findings, that there was a an underlying fee simple right. The statute says that MARTA doesn't extinguish the possessory rights, quote, so long as such person remains in possession. So we believe, and the trial court found, that there is no time limit for the possessory rights. It's not a life estate. The statute, if it wanted to create a life estate, could have used those terms. That has a very particular meaning under the cases in real estate law and under the homestead cases. It's not exactly like a tenancy, as that term is used for leases, because that includes certain obligations on the landlord and the tenant that aren't outlined in MARTA. And we have very little guidance in the case law about exactly what the rights and responsibilities of the title owner and the possessor under this statute would be.
So, counsel, it's your position that even if the appellants had an ownership interest in the property and met the statutory exception, the martyr extinguished their ownership interest and reduced it to a possessory interest?
Yes, Your Honor. That's what the trial court found, and we believe that was the correct interpretation of that statute. And the trial court went on to try to fashion some guidance for the parties and reserve jurisdiction over time to outline particularly the payment of property taxes, which was, in this case, very contentious. It may have been the driving factor in the litigation.
Have the property taxes been paid for 2015 as well as 2016?
Yes, Your Honor. I don't know what the status of the 2017 taxes is, but I believe those have also been paid.
And so was the total amount divided between 11 or 12?
I'm not sure if the record is clear on exactly how it was allocated. Apparently what happened is the lawyers and the parties erred in the denominator. At some point, there was I don't remember if it was a filed stipulation or if it was something outside of the record, and the denominator should be 12, it was 11, and we recognize that that is a factual mistake that appears in the final judgment or in the order adopted in the final judgment. But that can be, this court doesn't have to reverse the final judgment for that issue to be addressed. The parties can go back to the trial court to seek relief regarding whether the denominator should be a different thing, whether the allocation should be different, whether there are any other issues not addressed in the final judgment that need to be addressed given this non-title possessory right.
And I think you're getting to exactly what my next question is. Certainly, and I don't mean to suggest that property taxes are inconsequential or not, but it seems to be much more consequential. What is the definition of this possessory right? What is it that the parties are left with, particularly where they were seeking partition of the parcel? Was there any requirement under the statute or any other requirement that the trial court would have to make that more clear? Or alternatively, would the appellants have the right to seek some kind of declaratory judgment as to the status of their property interest?
The answer to the first question, Your Honor, is no. The statute does not give any direction or any more guidance that would require the trial court to make detailed findings. In fact, I think the trial court may have done more than what the statute required to try to answer some of these questions that only flow from the finding that the parties' rights are merely possessory. And whether in the future the parties would need to file a deck action or whether they could simply seek relief under the existing judgment, I don't know. I haven't given a lot of thought to that question, but I am confident that in one venue or another, if disputes arise in the future, there would be a forum for redress and that reversal of the final judgment isn't necessary to shed more light on it. The threshold issue is if the trial court said, if the trial court's understanding of the so long as such person remains in possession is not the correct reading of that statute, what is it? I was not trial counsel in this case, so when I stepped in and worked with my partner to get a handle on the facts and the record, that was the first question I had is, that seemed to me to be a reading of the statute that's most consistent with, ordinary use of the words in the English language. What's the alternate reading? And I must say, I never understood exactly what the alternate reading was. It wasn't until the reply brief on appeal that I first saw what I thought was what appellants urged this court to adopt. And that is, appellants say in the reply brief that the so long as such person remains in possession actually refers to the period between the action and the root of title under MARTA, which is at least a 30-year period, but it could be much longer. In fact, my friend, I think, mentioned that same thing in her oral argument and said that these parties did meet that. Confusing the matter a little more, there are references in the orders that the court entered to continuous possession. But that's not in the statute. There's no statutory requirement that to qualify for the possession exception, you have to have occupied or possessed the property for 30-plus years. The statute just says saved from extinguishment are rights of parties in possession, so long as they remain in possession. So we don't think there's any support in the statute or the law for imposing a requirement that to qualify for that exception, one must have possessed the property for decades. We believe it's sufficient under the statute that you possess the property at the snapshot when the MARTA action, when MARTA is being asserted as something that's going to extinguish the rights for however long you asserted it. For example,
Can I ask you a question? The subsection 3 exception there, has it ever been applied to carve out a portion of the property? What I'm getting at is the statute says the rights of any person in possession of the lands. So the focus is on the lands, not the mobile home or what, and so forth. What I'm getting at is if we disagree with you and found that James Dorsey has a possessory interest under subsection 3, what would that look like? Would it be that Mr. Dorsey gets a equivalent legal right in the whole 18 acres, or does he have the right to ingress, egress down whatever road that leads to the mobile home, and maybe perhaps some portion around it that he's maintained? I'm not quite following how this all would operate when the focus of the exception is on the lands, not the personal property.
I think, Your Honor, in this case, if the court were to find that Mr. James Dorsey did possess the property and qualified for the exception, that he would apply, that he would be entitled to continue such possession, which is what the statute says. So then I think it would be necessary to see what the scope of that possession is. The trial court grappled with that same question as well, and in the order on non-jury trial, the court said, and I may not get the words exact, but words to the effect of the parties can continue to possess that area they presently possess, which from the face of it, I can't look at it and know what that area is, but that is something that certainly some facts, if that issue needed to be fleshed out at some point in a future case, then I think it would not be the full 18 acres unless you possess the full 18 acres. So if you fenced it in and cultivated it in a different set of facts, then it would apply to the entirety of
But
the
in terms of creating marketable record title, how would that tell a bona fide buyer what possessory interest, for instance, Mr. Dorsey had?
Well, it wouldn't, Your Honor, and that's not what MARTA aims to do. It recognizes that there are unrecorded rights that parties may have, that the real estate industry recognizes there are unrecorded rights that parties may have. But if somebody's in possession of lands, and it's why we think the trial court was correct in saying that the constructive possession theory that was advanced below is inconsistent with MARTA, because you can't go out then as a buyer and see somebody's possessing this land.
But I thought MARTA, maybe I'm mistaken, I thought MARTA basically said that if there's 30 years and there's nothing on the property records, then here's how we handle it. And from that point forward, there could be a possessory interest that, or am I getting it backwards? Is it the possessory interest must occur before MARTA applies and vests title, or can there be a possessory interest after MARTA applies?
Your Honor, we believe that that the possessory interest MARTA might preserve would arise after the MARTA root of title. So the root of title, we got to go back at least 30 years and find
85.
Find something. In this case, it was the 85 deed. In other cases, you might have to go back much farther than that.
So if the facts show that individuals had a home, carved out an acre, had an ingress, egress, as driveway and so forth, lived there, post-MARTA and so forth, and they could establish it as open, notorious, continuous, all that, that wouldn't be a record. And someone with Google Maps might be able to see it or whatnot, driving by, but I thought Marta was more looking backwards and trying to clear the title versus forward.
Your Honor, what Marta's trying to do is limit how far you have to look backwards, okay, to at least 30 years till you find that record title transaction. Then we don't have to go back to Spanish land grants anymore.
Right.
But it recognizes, for example, there's easements, there's a list of things in the statute that MARTA's not attempting to affect. And MARTA doesn't say that if you qualify under the possession exception, therefore you have some rights. All MARTA's saying is we're not going to bother those rights. We're wiping out, we're extinguishing the title rights. We're not going to look at the possessory rights. So I don't recall if in your example there was a lease or what the circumstances.
No, it was just, they're just there.
They're just there.
There's no
So if they're
document.
just squatting, then they may have no rights. Ejectment action to follow. If there's a lease, whether it's written or unwritten, then you'd look to those terms and say, okay, then those rights are preserved. But it's limited in any event to what the underlying rights are. And that, to me, is what flows naturally from the so long as language in the statute. I don't see any factual or any textual support in the statute for the argument that so long as imposes this additional requirement that you have to show you've possessed the property for more than 30 years. So my review of the record leaves me unclear of what appellants say that language should mean. I don't think that the argument of the 30-year requirement squares with the statute. So maybe we will hear before we're finished here today what that alternate reading is. We believe that the trial court's reading is the only one and the one that makes the most sense, and for that reason we ask the court to affirm the final judgment.
Thank you, counsel.
I apologize. I forgot to introduce Clayton Knowles. He was trial counsel below, who's sitting at counsel table. I'm sorry. I guess I was a little nervous when I got up. You've asked a lot of questions, and I think I'll probably jump around to try to answer them in the order that you asked. There was a couple questions about them the Dorseys not being in the record, and that would be solved in this case if there was a partition, which is what they counterclaim for, or if there was a probate action, and that would establish it, and then their interest would be clearly established in the record for anybody who would eventually want to purchase this property. And our theory is that they're, fee simple, they're tenants in common. The possessory interest is, I've tried to figure it out. I think Judge Rowe asked about the definition for that. And, like I said, it's some sort of tenancy, like a landlord-tenant. I think, it occurred to me, you have to file back to your law school days, but it seems like it's some sort of reverter maybe, too. I'm not really sure. Like, they get to stay on the property, but if they leave, then the property reverts to the Robinson-Thompson. So, and that's, again, that's a limitation, that's an alteration that's affecting their interest. So that's contrary to the exception in the plain language of the opening paragraph, which is MARTA doesn't extinguish or affect those rights.
Could you take 30 seconds to describe to us where the two homes are of Mr. James Dorsey and Lillian Dorsey? From my reading, it sounds like Ms. Dorsey's home is on a 2-acre plot within the 18 acres, or I'm sorry, outside the 18 acres, but within the first 20, and that Mr. Dorsey's, it's not clear whether it's within the 2 acres or somewhere else on the 18 acres. Is there any certainty to that issue? Is there any certainty? Can you tell us where these?
Well, I've looked at the map on it. And,
Well, actually, this is the map, right? Can you tell us?
yeah,
where
I've looked at the map. It seems to, well, there's an argument in here that the 2 acres isn't really 2 acres. Mr. James Dorsey testified to that. It looks like from the drawing I have, like what the 2 acres is kind of bisects his mobile home there, kind of half of it's on half of the others, but he is right next to a road there. And, maybe these people could work out, Mary Thompson did concede at the trial that if it's not 2 acres, it should be 2 acres. So maybe they could work that part out. And
So the answer is you don't know. We don't know. We don't know from the record where these two homes are on the property precisely.
well, I think I read someplace that there is a house on that 2 acres, but that's not where Lily lives. Her affidavit gave her address, and the map that I looked at gave numbers for everybody's address, and her mobile home is not on that 2 acres. And it was undisputed that she hadn't lived on that 2 acres. She might have gotten it in a deed, but she's never lived on it. She's lived on the 18. There's been a lot of talk about taxes in this case, and I just, I know that kind of goes to the 4th issue, but I just want to make a point that MARTA is not a remedy for taxes, that they have a remedy for taxes and contribution from the tenants in common, and that's what they should be doing, not going to MARTA about that. And as for the mistake as to 11 or 12, and there's some question about that, it was 11 households, and that's because there's 7 Dorsey households, 3 Robinson Thompsons, and then there was 2 other Robinson Thompson relatives that were there, and they had, according to the documents that they submitted, been collecting from each of those households. And so that's where the 11 households, the 11 number comes from. It's households, it's not people, because there's 12 people involved in this litigation. And I just really want to stress that there's been a lot of talk about what MARTA does and how it creates this possessory right, but I would just really want to focus on the fact that MARTA is all about title. Title. So it's not about possession, it's about title. And it's going to extinguish defects on the title. And that's really what, what this judge has done, is created something that doesn't affect title. And so she's frustrated MARTA, and she hasn't, and she's lessened what they have. As for, once again, going back to the, to what, how their possession is, as I said, if it was partition or if there was a probate, then I'm counting up, I guess, I'm out of time. If there was possession, they would be on the record. That would, their possession gives a duty to inquire to anybody who sees this, and that their possession has to be during the MARTA period, that 30-day period. So I see I'm out of time. Thank you for my 30-some seconds extra. If you have any other questions, then I'm going to ask you to reverse, and I rely on the remedies that I asked for in my briefs too. Thank you.
Thank you, counsel.